All right, now we're going to talk about the fun subject. We're going to talk about licensing requirements. All of you are here because there are licensing requirements. So, in order to be licensed to sell prepaid legal in this state, there are some things that have to happen. Okay, and we're going to go into that real quickly. So, if you are a resident of this state applying for a license, let's get some general things out first. When you apply for the license, how long is that license valid from the time it's issued?
2 years.
2 years.
2 years. Okay. What does the license cost?
$100.
$100. That is perfect. Now, what are the other requirements? You have to take and pass a
Test.
Right. You have to take and pass the test, or the prepaid legal license examination. There are a lot of things in this section that are specific to definitions. Limited line products, negotiations, person or individual, personal lines, sell, solicit, terminate, uniform business entry application. There's a lot of different things in here that are going to be specific to the insurance world and specific terminology that you're going to need to understand, but I wouldn't spend a lot of time on it, because what we're really looking at is what's going to be involved to get your license. And that is, each individual applying for an examination shall remit a non-refundable fee as prescribed by the director. So, is there a time or a situation where a test fee is refundable? No.
If that's a negligent,
So,
that's in person.
okay, no. Is there a time where the license fee is refundable? No. And I promise you that's true, because someone that I worked with applied for the wrong license twice before applying for the right one. So in that case, his license fee was $300 because they're non-refundable, non-transferable. So it's $100 to apply for the right one. So, and what is the license called in this state? Prepaid legal. It's under the Missouri insurance portion. So it is an insurance license for prepaid legal. Got it? Okay. An individual licensed as an insurance producer in another state who moves to this state shall make application for their Missouri license within 90 days of establishing a legal residence to become a legal resident, licensed resident of this state. So, we're going to talk about a fancy word, reciprocity. Okay, Missouri is a reciprocity state. It means that in most cases, if another state will recognize Missouri's insurance license and the requirements to get the Missouri insurance license, then they will consider that a satisfied requirement in another state. For example, if you live in Illinois, the requirement to get a license in Illinois is no test. The fee is $58. You apply for a license and you become licensed in Illinois. Missouri recognizes that license, and therefore you don't have to jump through any hoops to become licensed in Missouri. You simply pay the $100 fee and you are licensed. Okay? You do not have to take a test. You do not have to go through any of that. If you're in a state that has a license and you become licensed in that state, in most cases it's going to be recognized in Missouri. So no examination will occur. If you move to Missouri and you have an active license in another state, you can simply transfer it. Okay? But if you move to Missouri without a license in another state, you move here, become a resident here, you don't have a license, you have to go through the same process that a standard resident of Missouri would go through. Any questions on that? Okay. So, the license is good for a term of 2 years. The biennial fee for a producer's license is $100 for each license. An individual producer who allows his or her license to expire within 12 months of the due date of the renewal fee may reinstate the license, but at a cost. There is a monthly penalty for up to 12 months for not renewing your license on time. Who can tell me what that penalty is?
$25.
$25. So if you screw up, you're going to spend $300 for a $100 license on top of the $100 license. So renew it on time. Keep it active. Insurance producer shall inform the director by any means acceptable to the director of a change of address within 30 days. Somebody who has done it recently or who has ever done it, tell me what will be an acceptable means of notification. Will, I know you just went through this.
30 days.
Yeah, but what is an acceptable means of notification? How did you notify the director?
Oh, I went through the NIPR website.
Right, so you go to the NIPR website, you can send a letter in writing, there's different ways that you can do it. So for any questions about that, I don't think they're going to list a ton of specific things on the test, but know that it's by any means deemed acceptable by the Department of Insurance or the director. Again, we're going back to the director having all kinds of crazy power. So they have the ability to determine what's acceptable and what's not. Okay? Insurance producers shall inform the director by any means acceptable to the director of a change of address within 30 days. Failure to do so results in a fee not to exceed how much per month?
$10.
$10 per month. So, if they try and serve you at your former address and they cannot get in touch with you, what might the director do? They may suspend your license until they can get a hold of you. And at that point, if your license is suspended because you failed to notify them and you're conducting business without a license, you've just committed a Class C felony. So, it may sound something simple as sending in a change of address form, but it can get real serious if you don't. So it's important, and there's going to be different references to the time and date of required to do some of these things on the test, for sure. I mean, probably. Insurance producer shall inform by any means necessary within 30 days or pay $10 a month. Within 30 days of an insurer authorizing an insurance producer to transact business on its behalf, the insurer shall enter the name and license number of the insured producer in the company register of appointed insurance producers. What does that mean? It means when you join Legal Shield has 30 days to let the state of Missouri know that you are licensed to conduct business on their behalf, and they have to do it within 30 days. Does that make sense? Okay. Now, an insurer that terminates the employment, contract, or other business relationship with an insurance producer for any reason not set forth in section 375.141 shall update its company register of appointed insurance producers by entering the effective date of the termination within how many days? 30 days. We're going to get these days down. Now, here's the thing. If you're terminated from Legal Shield, what are they going to tell the Department of Insurance? Everything. They have to notify the reason for termination. If your termination for an act that violates or fails to protect the public, you will be held accountable for that. The Director of Insurance will have that investigated. If the Director suspends, revokes, or refuses to issue or renew a license pursuant to this section, he or she shall provide public notice. Why do they do that? To protect the public. And the public has to know if somebody that's in this room does something wrong, loses their license, so that the public has the ability to protect themselves. Make sense? Okay. No consideration for unlicensed persons. There's a lot in here. But what does that mean? It means you can't give anything. You can't provide anything. You can't pay anybody that isn't licensed. It is a violation of law to pay somebody that isn't licensed. They cannot get consideration for their actions. A person shall not accept commission or a fee. Renew or other deferred commissions may be paid to a person selling, soliciting, or negotiating insurance in this state if the person was required to be licensed at the time of sale and was licensed. What does that mean? One of the reasons why a lot of us join this company is what? We want to make long-term residual income. Okay, so if Steve is licensed and sells a policy and one day later he is no longer licensed, he can get paid on the policy he sold, and he will get paid forever and ever and ever and ever and ever on the policy that was written because he was licensed at the time it was sold. But if he sells a plan today and gets licensed tomorrow, we cannot pay him commission because he was not licensed. There is no consideration for unlicensed people. That's what that section means. Okay, does that make sense? All right. Okay, there's a lot of stuff in here that is going to be specific to the insurance world and the licensing requirements. So we're going to go through a couple of these and just make sure that you understand. So the purpose of the section I'm about to go over effectuates and aids in the interpretation of the definition of an insurance producer. In other words, we're going to define what it means to be a licensed person. Okay? Unless otherwise specifically provided by section 375.012, no person shall solicit an insurance contract in Missouri unless he or she is licensed, a licensed insurance company, or its employee transacting business on their behalf. Okay, so solicitation of an insurance contract does not include the following activities. And there's going to be some references to this for sure on the practice test that we do, but probably on the state test. Dispensing brochures and other information so long as there is no conversation relating to the terms of the contract. Okay, disseminating buyer's guides, applications, things like that. Receiving or recording information from a policyholder to give to an insurance producer. Okay, what you cannot do is negotiate the insurance contract. You cannot make expressions of coverage. You cannot say this is going to be covered, this would not be covered if you are not licensed. And even in some cases you can't do that if you are licensed. That's up to the interpretation of the insurer, not the insurance agent. So you got to understand that you're the agent. You are not allowed, just like we can't dispense legal advice, we can't dispense a definition or explanation of coverage. In most cases, we have to let them read that for themselves. We can give the general bullet points, but not the specifics of the contracts and how every single situation will apply. That is a violation of your license. Now, I know we speak in a lot of general terms. General terms are completely fine. When we do the briefings, when we do the group presentations, and when we read the brochure and talk about the things in there, when we tell stories, fine. Talking about specific exclusions, inclusions, terms of the contract, how they may be able to purchase or negotiating any of that stuff. We can't go into that. That's up to Legal Shield to do, or the Director of Insurance. Any questions on that so far? Okay, we're going to go ahead and stop at this point, and we're going to resume in the section when we're talking about conducting business online.